Thanks for staying with us. It's still iBrandTV, and now we're turning our attention towards the personal finance segment with Charles Fakoha. Now, an estate plan covers risk and financial management towards an eventual transfer of assets during and after a person's lifetime. Of course, proper planning takes cognizance of events such as retirement, incapacitation that's due to bad health or unforeseen circumstances, life insurance policies, provisions for minors, among others, some of which could take effect immediately the asset is created or after the death of the owner. Now, what are the numerous advantages of estate planning? We began the conversation yesterday and we'll continue that today with Charles Fakoha right here with us in the studio. Good morning. Welcome to the show.
Good morning, Samson.
Good morning, Mr. Charles.
Good morning, Margaret.
Yes.
Okay, so we began this conversation yesterday, but for the sake of those who probably missed out on the show, can you give us a summary of what we talked about yesterday in terms of what estate planning entails?
Yes, thank you very much. We've said estate planning. I don't want to sound technical now.
Okay.
Or,
let's break it down.
We're going to break it down, and we won't want to be like lawyers because basically I'm not a lawyer.
Okay.
I'm just a stockbroker and a financial planner. Estate planning is just simply a man or a woman. You are planning for your spouse or spouses, as the case may be, your children, in case the good Lord calls you, so that from your debts you are speaking. And you are speaking, trying to show that the properties you have left, you want it to be distributed.
Okay.
So that is basically estate planning. But it does not mean that it will start while after your death. Estate planning is done while you are still alive, because you must make the plan. And some of those plans become effective when the good Lord has called you.
Okay, so yesterday we talked about, the various aspects of estate planning, deed of gift, will, among others. Just kindly break that down once again.
Yes, these are basically tools of estate planning. And like I always say, you don't even really need to be a lawyer, to understand these basic things. The first one is the will. And like we said yesterday also, when you tell people go and write their will, they think it's a death sentence. It doesn't follow. And your will is only what we call ambulatory. That is, it becomes effective when you are dead. But as long as you are alive, you can keep changing your will. Yes. Like I said yesterday, once you acquire another property or your circumstances changes, then you can, and you want to include that in your will, you have that right to continue to increase it. So, but a will is just a valid document specifying how you want your properties to be distributed. Before that will becomes legal or effective, as the case may be, it has to be probated. That is, it must be registered, and of course the probate registry of the High Court will give it that validity. Then, and that's your will. They have said your will must be signed, there must be witnesses, but we have seen circumstances where oral will is also admissible in court, especially for military people.
Okay.
If you have somebody who is serving in the military and he has been drafted to Sambisa or Goza, where the insurgency is hot, and he now tells his colleague that, look, when anything happens to me in this place, I want all my property to go to my wife. And eventually, if anything happens to him, that oral statement he has made in the presence of his colleague can be admissible in the court of law as a valid will. We have seen it happen several times. Yes, that's for military personnel. Also in culture, there are some culture. If I tell the elders, I make another statement that this is my land in so and so place, if I direct it goes to my wife or my child, and the elders, they were there, they heard the statement. And of course, if I die, they want to ensure that as long as that land belongs to me, it will be distributed to the persons I have mentioned.
So sorry to ask, just to cut. What of in cases where these oral wills are tampered with, because the person is not there to say I said this or I didn't say this. For instance, a military man tells his colleague, or you tell your kinsman, I want this, and in your absence, they're not as nice as other kinsmen. They'll say, oh well, he said he should go to someone else. So in those cases that it can be tampered with, what do they, how are they sure that?
That's why we say credible witnesses.
Okay.
Credible witnesses. Of course, we know that it can
Just
be
to be
tampered.
sure, yeah.
Yes, and that's why they are saying for a statutory will, it has to be written down. And not just only written down, there are certain things it must meet for it to be a valid will. It must be signed.
Okay.
There must be witnesses. And the person must be of sound mind when you are writing that will. Then, of course, the court will look at all those before they will grant probate to it. The probate is, yes, we have recognized what you have written in your will. Then the people mentioned as executors in the will or executrix, I want to be gender friendly now, will now carry out what is inside that will according to the testator. That is the man who has written that will. Now, he is said to be a testator because he wrote a will before he passed on.
Okay, you just talked about executor now. I know we talked about that. Again, we're just trying to refresh before we now delve into the conversation. So, kindly differentiates between an executor and an administrator when it comes to estate planning.
Yes, you will see that most of what we have experienced, as stockbrokers, we're dealing with our clients. And that is why we took it upon ourselves. In training stockbrokers, they have a whole course that you do on executorship, trust law, and accounts. It's people who don't write will. And when they die, they have their portfolio, shares portfolio, so large that there's no will. Now, what do you do in that case? Now, the family members is usually the spouse, first of all. Then if there's no spouse, of course, the children. If there are no children, the parents.
Okay.
Or maybe uncles. Or no, brothers, if there are no children.
Siblings. Yeah.
Brothers of full blood. And the same father, same mother. If there is no brother of full blood or sister, the brother or sister of half blood.
Okay.
If there is none, parents. If there is no parent, of course, grandparent, as the case may be. And if there is nobody, of course, the government takes over. Now, let's assume now that there is a spouse.
Okay.
Now, the spouse can now approach the courts after getting all the requirements, because you must have a death certificate, then you approach the courts to grant you a letter of administration. That is, since there is no will, the court wants to now give you authority to manage the estate of that disease. Now, until that court grants you that letter of administration, if you deal with the estate of disease, it's illegal. Yes, because you don't have any legal authority to administer that estate. So the court giving you that letter of administration, of course, it takes time.
Okay.
6 months, 1 year, as the case may be. After you have paid all the necessary fees to government, then that letter is granted to you.
And the person becomes the administrator?
Yes.
Okay.
Now, we used to have where you have just one administrator, but we have seen people going to court, come in and say, no, this is illegal, it's fraudulent. So now, if you go to the probate registry now, Lagos High Court there, they will want at least two administrators. So if the spouse is alive, they will want one child. And if there is no spouse, they want at least 2 children to be the administrator, so that they don't want an issue. But I've seen cases where somebody will go to one high court, get a letter of admission, and happens to go to another court again, letter of admission. So there is a confusion. Of course, that is where the lawyers will come in and try to start. So once you have that authority letter of administration, then the administrators mentioned now in that letter now have that legal authority to administer the estate of the disease.
How about executioners?
Yes.
Executors, rather.
Executors, yes. For executors, they are expressly appointed by the testator. That is the man who wrote the will. It is stated in the will, these are my executors. So they are there. Like I said yesterday, they can be paid a fee, or it can be done because he believes in them. These are close friends, people he has a lot of confidence. So he might not say, I will pay you for this service. And every executor knows that you are not expected to be paid. But your duty either executor or administrator is to ensure that the assets of that estate are properly taken care of. If there are liabilities, because if the deceased person has some liabilities, he has to be paid. Then you have to pay government tax and all that. Then that is when you can now begin to distribute what he has written in the will.
Well,
Yeah, that is will.
Interesting. Now, just to ask, you mentioned estate planning. Are there other kind of plannings that involves how do I put it now? That involves
How to transfer,
your
wealth.
Yeah,
from
your
one-
wealth. Because if there's an estate planning, then maybe there could be other kind of plans.
Yes, but we'll still put everything under estate planning.
Okay.
And we have mentioned will. There is also trusts. For will, it has to do with the Wills Act of 1837, which became Will Act of 1958. Then now we have the current one now, the Wills Amendment Act of Lagos State 2015. That's what we are all operating now. Yeah, that's what we're operating now. And that one takes care of will. Now for trusts, we have the Trustee Act of 2004, where while you are still alive, you can set up a trust and you appoint trustees. All your property will be transferred to that trust, and the trustees are expected to hold that property in trust for the beneficiaries. You will not mention the beneficiaries, which could be your spouse, your children, and yourself while you're still alive. So that trust deed, because there is a trust deed already, will specify the beneficiaries. You can also benefit. So a trust comes into existence while you are still living, as long as you have set up the trust properly. When you die, of course, the other beneficiaries will continue. So for trusts, it's a private document. While will is a public document, because you must register your will in the probate registry. But for trust, it's a private document that you have specified. It may be only your lawyer might be aware of that trust. And you don't need to go through the courts, probate, for your trust to be effective. That is one way of estate planning. Well, you mentioned we also have deed of gifts.
Yes.
Deed of gifts. You see, yes, that one is also very technical. While the man is alive or the woman is alive, you might say, okay, this is my car. When I die, they should give it to Charles. Now, but they have to show that the owner, that's the donor, and the donee, that is the person you are giving the car to, there is no compensation paid. There is no consideration. That is why it is a gift. She gives me the car. I'm not going to pay her for that. It's a gift. Now, I don't need to take physical possession of that car. But as long as she has given me the key, and people see me from time to time, I use the car. Obviously, when she passes on,
Continue.
it is my car. Okay?
Yeah.
But there are instances where you might not accept that gift. And when that person dies, you can't, because you didn't accept it while the gift was given to you. So that's also another way that some people use to transfer their wealth to whoever they want while they are still alive. That the deed of gift, you don't need any lawyer, you don't need any court, but you just, even a house, you can even gift a house to somebody. But people must have seen that the person has access to that house while you are still alive.
Okay. In wrapping up this conversation now, we talked about executioners or administrators can even be assets management firms.
Yes.
For the trust now, which doesn't have to go through the court, can an asset management firm also be recruited, to handle trusts in that sense?
Yeah, it's usually law firms, stockbrokers, and trusts. They call them trustees.
Okay.
Once they are registered for that function. Yes, they can perform that. So I don't want to mention some brand here now. I will have mentioned some names of companies who...
Well, I've just sent you an invoice.
Of course, exactly. Who does that trusteeship job. So you just... In fact, there are very simple ways. You just go and talk to them. They just set it up for you. You go through it and you transfer all your properties, your shares, your houses, personal effect, everything. You just transfer to them and you give them the title document to those properties. Because they are now technically the owners of that. But they are holding it on trust for the
for the
beneficiaries.
beneficiaries. Okay.
Yes.
So finally, let's re-emphasize the need for estate planning to the viewers. What are the advantages? Why is it necessary? Why is it important?
Yes. You can't imagine somebody who has worked so hard, and at the end of the day, the good Lord has called the person, and there is commotion in the person's house. You think you have peace of mind wherever he is? Of course, when people say rest in peace, I don't believe in rest in peace. Because if there are problems, in fact, there is even a particular case where, according to fella, double wahala for dead body. In the church, the dead body was there. They wanted to say requiem mass or something like that. And before you knew what, another lady came with a child, the same Ashoribi, which was never known
And became
to the
an
present wife. And they started commotion in the church. And in that presence, the wife in the house just pushed the coffin, and dead body fell down. So you can see, even at death, you can see that the man is still being tormented. So estate planning will help solve all this problem. If everybody has been taken care of, then there'll be no problem. Then peace of mind. You're also happy wherever you are that the way you want your asset to be distributed, it will be distributed.
Okay.
Then if there are, you also reduce taxes you pay to government. So estate planning is a must for everybody. Yesterday we said when you start working, me I'm saying as long as you are up to 18 years of age, you are of sound mind, and you have started working or doing something, it is better to write your will. Don't say until I have a car, until I have a house, until I'm 50. No. You can do a will right where you are currently.
All right.
That's a fine place to wrap it up. Thank you so much for your time on the show.
Thank you for
Thank you
having
so
me.
much. That was Charles Fracker on the personal finance segment, putting us through the ropes when it comes to issues of estate planning, will, deed of gift, among others. We'll go on a break right now. When we return, it will be time to take you through the money motivation segment. Please do stay with us.